1. Under the Constitution, the House of Representatives has the power to impeach a government official, in effect serving as prosecutor. The Senate then holds the impeachment trial, essentially serving as jury and judge, except in the impeachment of a president when the Chief Justice presides. The President, Vice President, and all civil officers of the United States are subject to impeachment, means automatic removal from office. 2. The concept of impeachment originated in England and was adopted by many of the American colonial governments and state constitutions. At the Constitutional Convention, the framers considered several possible models before deciding that the Senate should try impeachments. Since 1789, only 20 federal officers have been impeached by the House, 16 of which were tried by the Senate. 4 were dismissed before trial because the individual had left office, 8 ended in acquittal and 8 in conviction. All of those convicted were federal judges. 3. Impeachment is a very serious affair. It is perhaps the most awesome power of Congress, the ultimate weapon it wields against officials of the federal government. The House of Representatives is the prosecutor. The Senate chamber is the courtroom. The Senate is the jury and also the judge, except in the case of a presidential impeachment trial when the Chief Justice presides. The final penalty is removal from office. There is no appeal. For so grave is this power of impeachment, and so conscious is the Congress of this solemn power, that impeachment proceedings have been initiated in the House only 66 times since 1789. Only 20 federal officers have been impeached, 3 presidents, 1 cabinet officer, 1 senator, and 15 federal judges. 19 cases have reached the Senate. Of these, 3 were dismissed before trial because the individuals had left office, 8 ended in acquittal, and 8 in conviction. Each of the 8 Senate convictions has involved a federal judge. 5. The American colonial governments and early state constitutions followed the British pattern of trial before the upper legislative body on charges brought by the lower house. Despite these precedents, a major controversy arose at the Constitutional Convention about whether the Senate should act as the court of impeachment. Opposing that role for the Senate, James Madison and Charles Cotesworth Pinckney asserted that it would make the president too dependent on the legislative branch. They suggested, as alternative trial bodies, the Supreme Court or the Chief Justices of the state Supreme Courts. Hamilton and others argued, however, that such bodies would be too small and susceptible to corruption. In the end, after much wrangling, the framers selected the Senate as. 6. There was also considerable debate at the convention in Philadelphia over the definition of impeachable crimes. In the original proposals, the president was to be removed on impeachment and conviction for mal or corrupt conduct, or for malpractice or neglect of duty. Later, the wording was changed to treason, bribery, or corruption, then to treason or bribery alone. A final revision defined impeachable crimes as treason, bribery, or other high crimes and misdemeanors. 7. In the Constitution, the House is given the sole power of impeachment. To the Senate is given the sole power to try all impeachments. Impeachments may be brought against the President, Vice President, and all civil officers of the United States. Conviction is automatically followed by. 8. While the framers very clearly envisaged the occasional necessity of initiating impeachment proceedings, they put in place only a very general framework. They left many questions open to differences of opinion and many details to be filled in. Despite the open-endedness, as Peter Charles Hoffer and N.E.H. Hull note in their book Impeachment in America 1635-1805, thanks to the framers, a tool used in Parliament to curb kings and punish placemen was molded into an efficient legislative check upon executive and judicial wrongdoing. The power of the English House of Commons to impeach anyone, for almost any alleged offense, was restrained, the threat of death and forfeiture upon conviction and the interference of the Commons and the House of Lords with the regular courts of justice was limited. American impeachment law shifted, at first inadvertently and then deliberately, from the orbit of English precedent to a native Republican. 1. The word